So what do you do when the property is inherited by more than one person and some want to sell the home and others want to keep the home? As you can imagine, this can be a tricky scenario, and if the conclusion can't be made, you may require the assistance of your probate attorney and possibly end up in litigation. And trust me, you don't want that. Sibling disputes happen more frequently than you might think. Different personalities approach a house differently. Some family members may see the house just as an object or an asset and are perfectly fine with selling it and getting the proceeds and eliminating the hassle and expense of maintaining a house that they don't want. Other family members have every single corner of that home attached to a fond memory and are deeply and emotionally bonds them to the home. They feel like by selling the home that they probably grew up in, that they're letting mom or dad go forever. And those are powerful feelings, and it'll cause people to make some poor decisions. If there's one thing I learned in business and in life in general, is that usually the worst decisions are made when they are made emotionally. So as the personal representative or other sibling or heir, how do you deal with all of this? There are a variety of solutions. First and foremost, you yourself have to try to eliminate the emotional aspect of making decisions. For some, this makes perfect sense, and for others, it's very difficult. But if you can focus on articulately listing out the pros and cons of selling the family home from a logical perspective, then you are set up for a successful transition, whatever you decide. Likewise, you have to realize that others may be making an emotional decision, and it'll be your job to rein them in by working out the pros or cons of selling the home altogether. Once you have the emotions in check, one of the very first things you want to do is verify whether all parties involved own the property outright or are even designated as a beneficiary or heir. If they're not a beneficiary or heir to the estate, they may not have any say in the sale of the home anyway. The beneficiaries or heirs will be outlined in any living trust documents, or once you have gone through the probate process and the court has confirmed and designated heirs, they will issue documents that will confirm what is in the will or come to some other conclusion. The court determines this as they interpret the will or apply the law if no will exists, and how the property should be distributed. Next, determine the balance of the mortgage, if any, and the approximate equity of the property. Sometimes there's just not enough left over after paying off all the creditors, medical bills, and associated probate fees, and not worth the fight with the family members. If the property is in probate, the probate referee will make an assessment of the estate and provide a value or type of appraisal for the home. This can come in handy for determining any equity, but sometimes it can take a while for them to do that. So if you want a quicker assessment of value, just let us know. It's something that we offer at no charge. Now, share the findings with other beneficiaries to help them in the decision-making process. If there's little or no equity, well, that may simplify the decision for all parties since there's not much else to gain. On the other hand, if the home is free and clear or has significant equity, that can simplify or complicate things. Let's assume the property is worth $800,000 and there's two siblings or beneficiaries. This would mean that each party would entitle to $400,000 before paying out all claims on the property, creditors, taxes, closing costs, and probate fees. If one person is all about the money and just wants to cash out, but the other one wants to keep the family home, the one who wants to keep the family home would either need to come up with the difference to buy out the home, either from their own funds or by getting a loan. This is referred to as a buyout. Like anything, there are pros and cons to a buyout. One of the biggest benefits to a buyout is that on several occasions I've seen that the cash out sibling agrees to take less than the full amount because, well, they're just happy that they're getting some money and they're happy that their sibling got to stay in the home. This essentially means that the sibling who bought out the other sibling got a good deal on the home. One of the cons could be that there could be significant deferred maintenance on the home, requiring the buying sibling to potentially absorb the cost of those repairs unless they can determine what that cost is up front and have the other sibling agree to split the cost, since that cost would have likely been included if the home were sold on the open market, effectively eating away any equity that existed. Also, if the home was free and clear and worth $800,000, but there was $150,000 in outstanding debt to be paid, for example, that only leaves $650,000 in equity to the estate, or $325,000 for each sibling. If there was no cash left in the estate to cover that outstanding debt, the buying sibling would need to get a loan to cover the debt on top of the buyout from the other sibling. Now, with a little creative math, that debt can be absorbed from the equity of both siblings after the loan was issued, but it would require some kind of workout between the parties. Unfortunately, if a win-win situation can't be worked out between the beneficiaries and their attorneys, well, then the next step would be litigation. If I can give you any advice at all, it is to avoid litigation at all costs. Try to work things out, especially on simple estates, or any equity that you have will get eaten up by legal fees and everybody will be left with much less. If you do find yourself in litigation, oftentimes this will involve what's known as partition, and involve a partition referee who is a neutral third party appointed by the judge to oversee the partition or division of real and personal property. Usually the property is sold by the referee and the proceeds are dispersed by the court to the owners, essentially taking you out of the driver's seat. You can only imagine that this would significantly increase the legal cost to the estate, taking away any equity that might have otherwise been shared. I was helping two brothers in the North Tustin area, and it was very much like I described. One wanted to sell and one wanted to keep the home. Before all of the normal expenses of the probate, they had roughly $380,000 in equity that they could share. The one who wanted to sell was local and started doing expensive repairs to the property without consulting the other brother, who was out of the area. He was doing this to increase the appeal of the property and ultimately increase the equity once it sold. When the brother who wanted to keep the property was able to come into town, he was furious and insisted that he be able to buy out the other brother at the original value of the home before all this money was spent on improvements, since he wasn't consulted. The brother who wanted to sell insisted on being reimbursed for the upgrades, and the fight began. It got about within 1 inch of a full-blown lawsuit, but the advice of some good attorneys, they both realized that they would have lost a lot more than they would have ever gained, and they agreed to split the difference. In the end, cooler heads prevailed. Did you know that when you hit the subscribe button and the like button, it helps this information get distributed to more people who may need to hear it? Also, if you have a specific question about selling a home in probate or in a trust, reach out to me directly and we'll get it answered for you. And it will benefit others because we'll probably make a video answering that question as well. And if you asked it, well, there's probably others who would like to know the answers as well. We have other great videos popping up on the screen now, so feel free to watch or browse around our channel to see if we've already addressed your question. I'm Anthony Nitz, the probate agent with eXp Realty, putting the pro back into probate.